Lordship, I'm praying for your Lordship's very kind leave to Lordship file an appeal, your Lordship, arising out of an order dated 6 September passed in a contempt jurisdiction, your Lordship. Lordship, I've applied for the certified copy since it's in the district of Darjeeling, your Lordship. The certified copy till date could not be obtained.
All right. Fine.
Appeal in connection with appeal.
After vacation.
Grateful, my Lord.
May I have your Lordship's kind leave to prefer an appeal? The order passed in a contempt application, my Lord, without the certified copy of the order, my Lord.
Server copy is there?
Server copy is there. Great.
Lordship, I am mentioning a matter. Lordship, it is supposed to come on 6th of December. Lordship has asked for a report. Lordship, actually, appellant is suffering from heart disease. Lordship has asked for if your Lordship take up this matter as to be mentioned.
May I mention the Rose Valley matter, my Lord? Your Lordship was pleased to direct the ADC to file audit reports with regard to two companies. One within 1 month from, my Lord, the date of the order, 21st November. Lord, with regard to BVCL, that audit report is ready, my Lord, for 11 years. Is it your Lordship's desire that I file it before the registrar or before
When
your
the matter
Lordship,
is called, you file.
Very well. But may I serve copies of the report?
Yes, you.
Lordship. Deeply observed.
Some matters today, your Lordship,
My Lordship, allow me to mention.
accommodate.
Yesterday
Yesterday, around 5 30 about 50 matters have been
We will check out, don't worry. We will accommodate, we will pass if necessary interim release. Monday, we will do. Yes.
My Lordship, allow me to mention there is a this is a CRAN we have filed against the appeal matter because of a parole application, my Lordship, as you suggested, because the son of the petitioner died. He was a 14-year-old son, my Lordship, and he is already in the custody for more than 9 years, my Lordship. So therefore, my Lordship, his parole application need to be heard. So my Lordship,
Filed before the court. Parole is filed before the
Already it has been filed as a CRAN, my Lordship, if it is brought in the top of the list on Monday.
for a court. Parole application is before the correctional home. So first make a representation before the correctional home, then approach us. Yes. Any other matter? Call the list.
Matter. New application item number 1.
Yes, Mr.
This matter I
Yes,
appeal for the petitioner, appealant petitioner. This is a matter relating to the demolition of the another structure in its entirety. The report was not submitted, correct report, and then you took into consideration on 25th September 2024, issued a contempt rule against the certain engineers of the Kolkata Municipal Corporation. Determinable date was fixed. On the determinable date, since the bench did not sit, my lord.
They were present, it was noted.
No, they were today also they were present.
All right.
Present on that particular day before the landed register.
What we do is we record their presence.
And also, Your Lordship directed is a report to be submitted by the Institute of Science, Technology and Engineering, the Shippu. Your Lordship called for a report regarding the extent of the unauthorized construction and to the demolition part, my lord.
Right.
That is to be submitted before Your Lordship's court.
Already inspection has been done.
First is the officers are present.
My lord.
Their presence is noted, dispensed with, let them file their affidavits to the
My
rule.
lord.
Correct. Second, is the IIEST report ready?
Well, I don't know that in the file it has been.
We have asked them.
1 second. Record
Record
IIEST report ache?
sometimes it is sent by the
Yes, directly to the court.
court by the register to place it before the last.
No, we have already approached them, but they are not present.
The inspection took place, my lord, I understand. Really? Ashini report? Report. IIT.
IIEST report এসছে ডিরেক্টর IIEST তার উপর কি সার্ভিস হয়েছে অর্ডারটা?
মানে they
I think-
inspection. I'm
But they have taken inspection. We have already asked them to come before the honorable court, but they
Unless
are not.
contemners are present in person, their presence is noted and dispensed with at present. They are directed to file affidavits in response to the contempt rule issued upon them by the adjourned date. Direct report. আগের অর্ডারটা দেখি অর্ডারটা
25th July, then it was modified. After that,
We know, we
because
know.
Kiloshi initially stated
We
that
know.
regarding the Bengal Engineering College,
we know.
since the name has been changed.
The report of director IIES and T
আমাদেরকে দেবে না?
Shibpur is awaited.
Wait.
The director is requested to submit the report as early as possible. Submit the report before the adjourned date or by the adjourned date. Matter will appear on
বলছি কোর্ট অর্ডার মাঝখানে বলতেন
17th of January 2025.
My-
All right?
they should if your lordship directs them to circulate a report, copy of the report, advance.
Get the report.
My
first.
lord, as your
The
lordship.
report comes before the
Ah,
My lord.
we are waiting. Report is not there.
My-
And ask your officers to file the affidavit in response to the contempt.
My lord. And
Why they did not comply with the directions and
but presents are dispensed with today.
at present, yes.
what the present yellow is dispensing.
নাম দিদি
All appellate side matters. फोटो का इशारा आ गया तो उसका दादा को ले हाँ, वो तो कल फिर लेडी को बुलाया हाँ आज कितना तो लगा नहीं तो चलता लेता है प्रेशर करने से होगा Do we mention?
But it asked me to serve a copy of an intimate Nimai regarding. I am appearing on behalf of the Nimai. My client is present in court in terms of my lord's conviction.
So where did he vanish?
It was never the matter was never appeared.
Entire state machinery is searching for your client.
No, my lord,
Matter never appeared.
my lord, your lordship.
All right.
Have a look to the attendance to the Thana in terms of my lord's bail order. Like every month. Like your lordship haven't.
He is appearing, but in court he is not appearing while appeal is being heard.
The matter was in the combined list. I am.
All right. This matter is now placed before after vacation. We are fixing this matter for hearing, right? Nimai.
Can it be 2 weeks after that so that some money is to be arranged to engage a senior lawyer?
Senior, you are reasonably senior.
I
What more senior you need?
Well, I am not expert.
You are not expert. All right, we are keeping this matter. Matter is fixed for hearing on 14th of January. 14th of January. That day, if you don't, your
No,
client
I
doesn't
will.
appear or you don't, we'll issue bailable bond.
I will. No, only tomorrow. Today morning, the flight.
No
has
problem.
come
You
with
take
the
your,
notice.
you take instructions, get ready, but
Yes,
14th,
yes,
end of story.
yes,
Then Supreme Court.
yes.
Appellant so and so or Nimai is present in person with his learned lawyer. He seeks accommodation to make preparations. Matter is fixed for hearing on 14th. Yeah. वही पैसा दिया इसको मर्डर करने के लिए. Yes. Next matter. Who's for petitioner? Yes. Another copy is necessary.
Yes, another copy is ready.
Ready? Second judge's
Can I
copy is placed on record.
to file this in your lordship? Permit to file it in your lordship's court.
Second judge's copy is placed on record. Now, after vacation, we fix for hearing.
As your lordship.
Matter will appear for hearing 1 week after vacation.
And my lord, interim order was there till today by the Honorable Supreme Court. Na, 20 तारीख को दिया है. Till 20th. My lord,
For what interim order?
my lord, kindly see para 13.
Huh?
No coercive.
Coercive step.
My lord, kindly see
You
para
give
13.
your wife appointment and no coercive step.
No, wife, no, daughter.
Why,
This is-
whatever.
My lord, this cannot be equated with a government job. My respectful submission, I need to.
Okay.
Well, it's a short-term contractual job. for
That
a
is not a,
period
who pays money for it? Mr. Mojumdar.
of-
Who pays money? Your client pays money for it. From which exchequer the payment is made for this ad hoc appointment?
No, my lord, if your lordship see the contract between
Mr. Mojumdar, who pays the money? Simple. Question of whether this is a public post under Article 311 is a different thing. Public servant under section under the Indian Penal Code or under the Prevention of Corruption Act has widest interpretation. The basic test is where are you discharging public duty? Second test, who pays? These two tests satisfied, you are done. Then what is there? We will keeping it 1 week after vacation. Your interim order we are extending up to 31st.
As your lordship.
The issue of 17A already answered to certain extent, and we'll do the rest. And remainder, whatever you argue, prevention of corruption applies or not.
Dictable.
The virus across party line.
No, I understand. my lord.
Virus is across
here-
party line.
My lord, I shall
There
distinguish.
is collegiality in corruption.
My lord, I shall distinguish from those cases in these cases also, my lord. But here, my lord,
relation to appointment, uska relation.
my lord, here on the basis of recommendation, it is permissible. My lord, I shall place it before your lordship.
You
Under
whatever.
the contract itself, it is permissible. But earlier, when I argued the matter before the single bench, but that document was not with me. Now they have annexed the entire document in the SLP, so that I got that document. I shall place it before your
Let us
lordship. No, এখন দাও sir.
public post, whether you can appoint through a private contract, and that too between relations. That is the question. Let us
But I shall not address these issues.
next. We are data entry operator. Private appointment. अच्छा कॉन्ट्रेक्चुअल एम्प्लॉय ठीक है पर पैसा तो कौन दे रहा पब्लिक ये तो दो टेस्ट है ना नेक्स्ट
Item number 4.
defect after question number 9 following all right, defects minor may be ignored, paper books within 6 weeks. Lady का बहुत लंबा हो गया है all staff should work. Thereafter, if you cannot finish with that, otherwise you have to have maximization of resource, then only addition. 6 from date. A, B, C, D, F. Paper, defects be removed, report be filed 2 weeks after vacation.
On the last occasion, your lordship had asked me to wait for the report. More than 1/4 already undergone.
Come up
That time
after
I was
half.
saying-
Come after half. Or we dismiss the appeal, go to SL. All immoral traffic. Authority on you.
My lord,
Ritunjoy.
my lord, I am for the de facto complaint.
May I place, my lord? On the last occasion, my lord, your lordships called for a
Sections, मतलब the non-billable sections are section 386 and 25 and 27 of the Arms Act, Your Lordship.
Petitioner and a list of criminal cases pending against the petitioner is placed on record. It is petition number 1 is placed on record. It is also contended that petition number 2 and 3 are his associates and carry on organized crime racket in extortion in the area. This is disputed by learned counsel appearing for the petitioner.
My lord, I have been acquitted in 7 cases, my lord.
She
My lord,
contends.
the last 3 cases that are pending, that are, my lord, in between 2021 to 23, there are only 3, Your Lordship. My lord, till date, I have not been convicted in connection with any of the cases.
She contends that most of the cases are old and she has been, and her client has been, senior counsel contends that most of the cases are old and his client has been acquitted in 7 of such cases.
And in all others, I am on bail.
Other cases, he is on bail. We have considered the materials on record, including the report of, report regarding criminal antecedents. Petitioner has been implicated in a large number of cases for the last antecedents. We have considered the including criminal antecedent. Report shows for more than a decade, petitioner has been implicated. Petitioner is implicated in a series of cases.
Well, may I only indicate?
In
petition number 2 and 3 are there.
Petitioner number 1 is implicated in a series of cases. Even in the last 2-3 years, cases have been registered against him alleging extortion. In light of the aforesaid materials and the nature of allegation disclosing involvement of the petitioner in extorting the victim, we are of the opinion petitioner number 1 is involved in an organized crime activity, and this is not a fit case to grant him anticipatory bail. With regard to petition number 2 and 3, we note there are materials to show that they are associates of petitioner number 1 and had threatened the victim. And had extorted the victim with by showing firearms. Accordingly, we are not inclined to grant
considers the
anticipatory bail to
circumstances
them.
also.
Yes.
But he waits for 2 months to file this case, does not take any civil remedy.
Next.
Matter, I am for the petitioner. Beg to appear for the state. My lord, on last occasion, my lord was pleased to call for a report from the state lordship as to whether what caused the miscarriage.
Which shows there is a misabortion by kick and punch by the present petitioners.
Told you.
My lord, there is
report is placed on record. Medical report is placed on record.
There are 2 petitioners, lordship.
Lordship, they both have.
We note from the medical report, it shows victim suffered abortion due to physical assault. Statement of the victim implicates the petitioner in the crime. In view of the nature of offense and materials collected against the petitioners, we are not inclined to grant them.
Grateful, lordship.
Understand? As soon as I knew.
Lordship. Lordship, allegation of assault, Lordship. Lordship, land dispute, 2 coacs already
We
granted
have
bail.
considered the materials on record. Co-accused have been granted.
He's a male person, Your Lordship.
Nature of injury.
Lordship, written is yes, but
Let us.
and kindly see page 23. Page 20.
Oh. Yes, see. We have considered the materials on record. Though injury is grievous, the incident occurred in the course of a free fight. In the course of a free fight, keeping in mind these facts, we are inclined to grant anticipatory bail. We know 180 subsection 2.
80 304B.
We have considered materials on record. Allegations of torture are general and omnibus. Victim how many years after marriage?
66 years, my lord, petitioner number 1 and husband granted bail. All allegation against husband.
We have considered the materials on record. Allegations of torture are general and omnibus. Petitioner is the father-in-law.
Father-in-law and mother-in-law. Petitioner.
Petitioners are the parents-in-law of the victim lady. Principal accused that his husband has been enlarged on regular bail. Accordingly, we are inclined to grant anticipatory bail. Next.
109. Two families sued because of possession of a common passage.
Yes.
Husband,
Injury,
daughter,
injury.
and wife, three were implicated. Husband and daughter have been granted anticipatory bail. It was ingested kerosene oil in mouth, 1 day in admitted in hospital.
We have considered the materials on record. Statement of the victim alleges petitioner administered kerosene, put kerosene oil in her mouth. Medical papers corroborate the statement. In view of the nature of the crime, we are not inclined to grant anticipatory. Next. 19.
That this petition, I was trying to withdraw it and file afresh. But petitioner number 1, my lord, she is not named in the FIR nowhere. my lord, wrongly, my lord, she has been incorporated as the petition number 1. And there are other statements, my lord, in which, my lord, we have made averments with regard to her. My lord, may I withdraw it and file afresh?
Whatever means against you.
My lord, averments is, my lord, all the complaints, my lord, may I say this, my lord, if your lordship, my lord, permits me to move it in case of the petition number 2 then. Because, my lord, he is FIR name. My lord, there was a dispute between the brothers and sisters over ancestral property. My lord, the de facto complainant is the Jamai Babu of the petition number 2. They were initially 3 sisters. 2 sisters relinquished their right over the property. They took money and went away. He did not agree. My lord, anyway, my lord, thereafter, my lord, there was a dispute in between us. My lord, the petitioner number 2 then lodges a complaint that we stay in Gagnapur, he stays in Chagda. My lord, some unknown persons came to his house, they hurled a bomb. Bomb did not hit him. The bomb, my lord, broke the glass panes. Glass panes fell on his body and he had suffered some injuries. My lord, this is the case.
But who threw bomb?
There is a statement, Milord. I have folded the statement, Milord. They have found that the father and the son were in the motorcycle.
We are rejecting petition number 2. We have
But
considered
only thing is that we have made a prayer before the investigating officer to check the CCTV footages.
all
But on
this
that day,
will
my lord,
come
we
out
were
later
not
on.
there.
We have considered the materials on record. There was property dispute between the petitioners and the de facto complainant. Statement of witness shows petitioner number 2 and his father was seen at the place of
But petitioner
occurrence.
number 2 is the father. Suman was arrested. He has been granted bail.
And his son was seen at the place of occurrence. Medical report discloses the bomb blast injury. Accordingly, we are not inclined to grant anticipatory bail to petitioner number 2, bearing in mind the extent of complicity of petitioner number 1 in the crime.
But
We are
petitioner number
inclined
1 is not named in the FIR. I was not pressing in
to
respect of.
petitioner. We are not Tarageda. Petitioner number 1 is not named in the FIR as an accused. There is no apprehension of arrest. Accordingly, her application for anticipatory bail is disposed of as withdrawn.
Grateful. Great.
As not pressed. Okay. So P1 not pressed, P2
Great.
Sure. Next.
Item number 20, I am for the petitioner. The allegation is under section 126, 2, 118, 1 and 2 and 109 of the BNS.
Yes, injury.
Injuries are grievous in nature.
This is the case of complaint and counter complaint. First, the petitioner lodged complaint on 1st November.
Consider the materials on record. Statement of witnesses implicate the petitioners in the assault. Victim suffered fracture injury. Under such circumstances, we are not inclined to grant anticipatory bail. Next.
For injured person.
Victim suffered grievous and fracture injuries.
My lord, I am appearing for the petitioner. My lord, main section at 326, 307, dispute among the cousin brothers regarding the landed property. There are case, counter
We have
case.
considered the materials on record. There is dispute between relations, injuries. Injury report does not disclose the injuries are grievous. Severe.
164 names, these two petitions.
Whether injuries are grievous may be assessed at the appropriate stage of the proceeding. Keeping in mind the opposite facts, we are inclined to grant anticipatory bail. Next.
My lord, case relate to my lord, so far old section is concerned. My lord, 302, 304B, 498. Petitioner before your lordship's mother-in-law and sister-in-law. My lord, his wife always wanted to live in separate mess. My lord, husband do not do so.
When did she
That's
die?
why she committed suicide. My lord, 15 days she survived. There is no allegation so far this type of allegation, my lord, nothing. No allegation against the in-laws. After 3 months, 156.3 and they demanding money. After 3 months, 156.3 has been lost against the entire in-laws family members. I have also, my lord, averred in my petition. They demanding, always demanding. My lord, after 3 months, 156.
My lord, petitioner number 2 is the married sister-in-law. She's staying in Kolkata for last 10 years.
And petitioner number 1?
Mother-in-law.
Sister.
Mother-in-law rejected. We have considered the material petitioner. We have considered materials on record, including statement of witnesses, statement of mother of the
First,
deceased.
my lord, 15 days she survived. My lord, no allegation.
Statement of mother of the deceased before magistrate discloses an oral dying declaration. This 160. Oh, this is FIR. Acha. In the FIR, mother of the deceased
The 150
claimed that victim made oral dying declaration implicating the petitioners, alleging petitioners poured poison in her mouth. Victim died due to poisoning. Full stop. Petitioner number 1.
Well, there is a UD case started. There is no
Hey,
allegation.
Mr. Bondol, petitioner's content, there is delay in lodging first information
3 months.
report and delay in lodging first information report. Petitioner number 1 is the mother-in-law and ordinarily resided with the victim lady. This corroborates the oral dying declaration. This corroborates the oral dying declaration against petitioner number 1. However, petitioner number 2 is a married sister-in-law and it is contended she resided in Kolkata. Possibility of false implication of petitioner number 2 cannot be ruled out. Under such circumstances, we are inclined to grant anticipatory bail to petitioner number reject the anticipatory bail to petitioner number 1, but inclined to grant anticipatory bail to petitioner number 2. Allowed. 1 rejected, 2 allowed. Next.
Lordship, I am for the petitioner. Although an altercation took place between the complainant and the present petitioner, for the reason of collecting the sugar leaves, sugar cane leaves.
Consider the materials on record. Injury report does not disclose grievous injury. Incident occurred over a trifling matter. Accordingly, we are inclined to grant answer.
Much obliged.
Next.
My lord, 302 reason of death is heart attack. And my lord, even if
How did he die?
He was weak. Weak and he was assaulted with
by one Mainul Islam.
is page 40.
Petitioner submit that there was a free fight between parties. Victim had a weak heart and died due to myocardial infarction. This is corroborated by the statement by the notings in the postmortem report. Keeping in mind these facts, we are inclined to grant answer. Next.
25, my lord. My lord, 25, 89 and 90 are all connected matters, my lord. Kindly it be taken up when 89 is called. My lord, I'm led by Mr. Dalji. He's in 30.
Where is the injury report? Huh?
My lord, the petitioner's injury report. My lord, yesterday you had asked for an antecedent list, my lord. I have prepared an antecedent list.
Do you have antecedents?
My lord, I have 4 cases against against me. In one case, my lord, I've already been granted anticipatory bail. The page number is 237 of the petition, my lord. This is the second FIR against me, my lord.
You surrender. We have considered the materials on record. Petitioner and others had assaulted the victim in order to compel him to return money. Full stop. Petitioner has criminal antecedents. Petitioner has criminal antecedents from the profile of allegations and the criminal antecedent of the petitioner. It appears he belongs to a gang of organized crime.
My lord, the
belongs
petitioner
to
is a lady.
She belongs to a group of organized criminal syndicate who are engaged to recover dues on behalf, who are engaged in.
No, my lord.
Here, my lord, these, the accused persons, the person who are not returning the money. She, along with the person who gave the money, went to their flat and then they assaulted.
My lord, the date of the incident was on the 12th of October. She has stated wrongly in her FIR that it was 11th of October. My lord, the one which have been granted bail, the complainant over there was Anand Datta.
Is involved in so many cases.
My lord, there are frivolous cases against her.
Then you take a report.
My lord, all the associates of the
This man,
You are for whom? Your state.
I'm for state.
To get a criminal antecedent, she is giving.
My lord, we have annexed all the FIRs in the
How
petition
is it there will be 4 cases against them?
against her.
Huh? It seems that they are involved in monetary transactions. Then they are money lenders. They are money lenders.
No, my lord, the petitioner is a teacher in a school.
Aha, teacher in a school is the ostensible role. Monday.
My lord, then kindly fill
All
89
matters
and
Monday.
90 also.
25,
89, 90, my lord.
same person.
Same person, my lord, and the brother of the petitioner number 1,
89
who has been shown as the husband in
and 90.
my lord.
They gave money to the complainant.
No, complainant gave money to them, and then complainant went to take the. They asked to complainant to come our flat, and then when they entered into the flat, they started
So
assault.
how many complainants they beat up?
My lord.
Same narrative in all.
My lord, there's one complainant called Anand Datta. His associates are all these people who have filed frivolous FIRs against me.
So the car they saying is told with
So why so many people gave money to you?
No, my lord, there's a Mistri Mason who used to work in our flat. We had given him an amount of money to do the work. He did not do that work. He left the job early. Then he is alleging us that we have not paid him the money to do the amount of work. We have restrained him for the car. My lord, there's one woman called Mukta Zaman who's a complainant in the second FIR, my lord. She has claiming that the petitioner had taken 1,50,000 from the complainant.
6 years back.
And 6 years back, my lord. There is no evidence. There is nothing. I've annexed all bank statements, my lord.
Next. Monday. ওই তিনটে একসাথে।
My lord, allegation under section 126, 117, 118, BNS Act.
What is the injury?
69 years old, his son assaulted his father, broke both his hands.
Others' hands were broken.
On a property dispute.
Huh?
On a property dispute.
We have considered the materials on record. Petitioner is the son of the victim. He assaulted the elderly victim, resulting in fracture injuries. In view of the aforesaid fact, we are not inclined to grant answer. हाथ टूट दिया।
Petitioner, my lord, 85, 123 and 109, 498, my lord, administering poison and 109. Husband has been granted anticipatory bail. Mother-in-law and lord uncle-in-law is before your lordship, lord.
The injury report shows nothing. Simple injury as per.
Question is not simple injury. Question is administration of poison.
An administration of poison is a statement of 164, 47. 47 is 164 statement.
Right. When was the poison?
Against mother-in.
No date specific date, perhaps. No specific date, perhaps.
That's is
164
at page 47. 47.
Got married second time and there is a previous 498 by her also. Second marriage for both two. She was blood also in custody because of the reason blood she pushed blood the father-in-law, for which father-in-law died.
Continuation offense, one after the other, that's.
And after blood coming out from jail, she has lodged the complaint. ওটা তো চার্জশিটও হয়ে গেছে বোধহয়। এটা না,
Not charge sheet.
no, no. In that matter, charge sheet has been filed.
Which matter?
Blood, why she is an accused. The de facto is the accused because the father-in-law blood died because of her. Now, that is the reason that she was arrested. She was in custody. Later on, after coming back from custody, blood, she has lodged this complaint.
After that, there was some torture, that's why it is.
No, no.
Petitioner number 1 is the mother-in-law, and petitioner number 2 is the uncle-in-law of the victim lady, of the de facto complainant housewife. They contend that they contend there was matrimonial discord. De facto complainant had misbehaved with her father-in-law and others. As a result, her father-in-law fell ill, died. She was arrested. Subsequently, they have been falsely implicated. They pray for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record. Allegation of administration of poison is not supported by medical evidence. It is contended de facto complainant had pushed her father-in-law, who fell down, and did she put, that is what সময় আমার বাবা বললে আমার মনে হয়
Card.
Cardiac arrest. কি বললাম, it is contended there was
Page 20.
there was a skirmish between the de facto complainant and the in-laws. At that stage, her father-in-law died. She was arrested. Full stop. A possibility of false implication owing to matrimonial discord cannot be ruled out. Accordingly, we are inclined to grant answer.
Obliged, deeply obliged.
Next.
I'm for the petition. 498 is 300 634. Husband has been arrested and granted bail.
How many
Where
years
the-
after marriage?
3 years of marriage.
We have considered the materials on record. Petitioners are
Mother-in-law and brothers-in-law.
in-laws of the victim lady. Principal accused that his husband has been enlarged on bail. Uh, keeping in allegations against them are general and omnibus. Under such circumstances, we are of the opinion custodial interrogation for progress of investigation is not necessary and they may be granted and sued.
I'm deeply opposed.
Next.
Appearing for the petitioner, Your Lordship. One bike and one e-rickshaw collided while returning from a local village fair. The biker complainant being drunk had a heated altercation. After 2 days, this case was registered. Your Lordship, counter case is also there. The parties are distant relatives living in the same village.
We have considered the materials on record. A skirmish broke out due to a road traffic accident. Petitioner number 1 caused grievous injury. Hence, we are not inclined to grant anticipatory bail to him. Keeping in mind the extent of complicity of petitioner number 2 in the crime, we are inclined to grant him anticipatory bail.
My lord, I am for the petition, Lordship. Second application, Lordship. There is no change, Lordship. Only one prayer, Lordship. Petitioner is a lady and she has a 3-year child, Lordship.
Prayer for anticipatory bail of the petitioner was rejected earlier. There is no substantial change in circumstance since then. Accordingly, the subsequent application of anticipatory bail is rejected. Petitioner is directed to appear before the jurisdictional court and pray for regular bail within 7 days from date. In the event petitioner does so, her bail prayer shall be considered independently and in accordance with the law. Great. Next.
I am for the petitioner, my lord. Allegations are under section 137, 140, 351 of the BNS, my lord. What happened, my lord? One Mohammed Miraj took away the victim lady.
That is the 164 of the
These
victim.
are the elder sister and the brother-in-law.
What is the role of petitioner number 2 and 3?
Well, they are the sister and the brother-in-law. They handed over the victim to the father on the next day. That is in page 8, 161 of the victim's father.
All right. Petitioner submit. We have considered the statement of the victim. Petitioner number 1 threatened and kidnapped the victim. She was taken to Bombay. Keeping in mind the primary role played by the petitioner number 1 in the crime, we are
But
not.
petitioner number 1 is the brother-in-law
not
and
principal, not-
petitioner number 2 is the sister.
Oh, the
Principal accused is not preferred.
where is the principal?
Well, anticipatory bail I will file.
He should surrender. All right. Otherwise, these people will not get answer. Monday.
Monday.
Next.
I'm for the petition, Your Lordship. Offense under section 3580 subsection 2 and section 85 of BNS. Petitioners are the father-in-law and mother-in-law.
How long, how many years? after-
4 to 6 months.
6 months.
4 to 6 months.
We have considered the materials. on
Husband
record.
surrendered voluntarily. Your Lordship.
Petitioners are the parents-in-law of the victim lady. She was subjected to torture over demand of dowry. Within 6 months of marriage, she committed suicide. In view of the aforesaid incriminating materials, we are not inclined to grant Anticipatory. Next.
36, my lord, I am for the petitioner. This matter, my lord, offense allegedly committed under 316 of the BNS, criminal breach of trust. My lord, I have no connection with the complainant. Nothing was recovered. My lord, my lords may be aware that unless there is a contract which emancipates the trust, my lord, the 316 does not lie. I have no relation with the complaint, be it breach of trust or be it gain of trust. The contract is the, my lord, origin, and the trust is a species out of that. My lord, there is no connection between the complainant and the offender, the principal accused.
Transit interim Anticipatory bail, my lord. My lord, you will be the Lordship.
I know.
24.
First, give notice to the Guntur police station. Officer in charge shall notify Guntur police station with regard to pendency of the proceeding. You go and surrender.
My lord, at least some protection may be granted, my lord. Because on 24th September, my lord, some police personnel came in my house.
No immediate apprehension of arrest.
Yes, the 24th September, police
Came,
personnel
but now
came.
they are not there.
My lord, they will again come, my lord.
And if they come, by that time you can go.
My
You
lord,
can go.
my lord, there is no connection with the
Sir,
complainant.
again saying, all right, give notice to Guntur police station. Petitioner contends that he is a resident in the district of Hooghly. Police personnel attached to Mongolgiri Town Police Station, Guntur, Andhra Pradesh, came to his residence to arrest him. At that stage, he came to know of the registration of the first information report.
I am not the named accused.
At that stage, he came to know of the first criminal case in respect of which he is sought to be arrested. He apprehends arrest and prays for transit anticipatory bail. Notice be issued upon Mongolgiri Town Police Station. Officer in charge, petitioner shall notify officer in charge Mongolgiri Town Police Station with regard to pendency of proceeding. Officer in charge of, you are appearing for whom?
The state, my lord.
Acha, state shall also notify the said police station with regard to pendency of proceeding and submit report with regard to the materials collected against the petition.
Only humble prayer, my lord. At the time of giving leave by this honorable court, was pleased to react, my lord, to submit the actual copy of the FI. My lord, that they feel that, my lord.
That is why we are asking you to place it on record. Matter will appear after vacation.
I am grateful, man.
In that judgment, they've said that a notice has to be given to the outstation police station. That is why we are saying notice to the outstation. Next, Nagaraj.
Petition, my lord. My lord, 285 and 9 of MPO Act, my lord. 3%
85 is 353, na?
No, my lord. 285 IPC, my lord. 285, my lord. And my lord, 9 IPO.
We have considered materials on record. Co-accused have been granted anticipatory bail. Petitioner stands on same footing, allowed. Next.
38, I am for the petitioner, Lordship. Lordship, petitioner is aged about 22 years, VG is 15 plus, Lordship. Love affair, Lordship. 12 Fox, Lordship.
Give notice.
Lordship.
Give notice. It is contended there was a love affair, there was a romantic relationship between the
Number one.
Petitioner number one and the victim. Officer in charge shall notify the victim with regard to, there is only one
Only
petition.
one petitioner, Lordship.
Petitioner number one. Okay. Officer in charge shall notify the victim with regard to pendency and legal representation 1 week in view of the materials on record. We direct petitioner shall not be arrested in this case for 2 weeks or until further notice. Next.
My lord, 39, I'm for the petitioner, my lord. There is a case and counter case, my lord, family dispute, my lord. 58 days delay to lodge complaint, my lord.
We have considered the materials on record.
My lord, the petitioner were assaulted by the de facto complaint, my lord, twice, my lord. Page 9, my lord, medical report.
There was a free fight between parties. Petitioner suffered injuries. There is delay in lodging first information report. Injury report does not disclose grievous injury. Under such circumstances, we are inclined to grant answer. Next.
I am appealing for the petitioner. Lordship, allegation against the name of the petitioner under section 318 of the BNS as well as 63 and 65 of the
They were selling fake
Lordship,
water purifiers. There is seizure from the petitioner.
Alleged deceptively similar commodity has already been seized. For progress of custodial interrogation for progress of investigation is
One
not
of the
necessary.
co-accused already
Accordingly, we
released
are
the base.
inclined to grant anticipatory injunction. Trademark. Next.
Malad, I'm for the petitioner. Malad, there is a injury, Malad. I know, Malad. Problem is that there is dispute between the own brothers, Malad.
Own maybe. So what?
My lord, I'm appearing for the de facto complainant. My lord, accused and the de facto complainant are the brothers. There was a dispute, but now there is no enmity between them.
It is true, Malad, but
161 of the injured, the petitioner who has
Petitioner contends there is that the dispute between him and the de facto complainant, who is his own brother, has been resolved. He pays for anticipatory bail. This is supported by learned lawyer for the de facto complainant. We have considered the materials on record, including the injury report. Whether injury report does not appear to be life-threatening, injuries noted in the report does not appear to be life-threatening. Under such parties are related to one another and have resolved the dispute. In this backdrop, committing the petitioner to custody would not serve any worthwhile purpose. Accordingly, anticipatory. Next.
Well, I have served, not yet received, my lord.
164.
Well, 498 with 376 and 307. Well, brother-in-law is before your lordship, my lord. Husband and other in-laws has been granted anticipatory bail. FIR started pursuant to a complaint made under section
164, page number 33 and 33A, my lord.
3 months delayed FIR and she denied her medical examination. Charge sheet filed, my lord.
Petitioner contends he has been falsely implicated due to matrimonial dispute. Officer in charge shall notify the victim with regard to pendency so and so 1 week, keeping in mind the nature of allegation and the submission made on behalf of the petitioner. Petitioner shall not be arrested for 2 weeks or on further orders. Next.
Obliged.
My lord, I am for the petitioner. Petitioner has already been arrested, my lord.
Petitioner has been arrested.
For not pressing the application, my lord.
Disposed of as infraction.
My lord, I am praying for not pressing the application.
Infraction. Next.
Get.
My lord, 44, I am for the petitioner, my lord. 108 and 3 of subsection 5 of BNS, my lord. My lord, petitioner before your lordship is the mother-in-law of the deceased, my lord. My lord, husband died, my lord, and wife and sister-in-law already granted bail by the learned court below, my lord.
Do it later. Yes.
My petitioner is the mother-in-law, my lord.
Petitioner is the mother-in-law of the victim. It is contended victim's wife had an illicit relationship. As a result, he committed suicide. Keeping in mind role of petitioner in the crime, we are inclined to grant anticipatory bail.
Great.
Illicit relationship, who and have commit suicide.
But I am appearing on behalf of the petitioner, my lord, after 13 years of marriage, 498, 323, husband, my lord, initially.
Not complies, she is the second wife and.
We have considered the materials on record. Allegations of torture are general and omnibus. Keeping in mind the aforesaid fact, we are of the opinion anticipatory bail petition may be granted anticipatory bail subject to condition. Meet investigating officer once in a week and further. Next.
But 306, we are the non-Nandai as well as business partner. FIR lodged after 9 months. In between, there is a civil suit at page number 14 for deed.
Well, 164 statement is there, my lord. Postmortem report, my lord, the
Suicide note.
no.
We have considered petitioner contents. There was business transaction between the petitioners and the deceased. Full stop. Out of depression, the deceased committed suicide.
Soon before her death, he disclosed their name, my lord.
So
164 statement, my lord, that due to
After
their
9
torture,
months,
my
this
lord, he
FIR.
committed suicide. That he has stated. His dying declaration, my lord.
After 9 months, this FIR.
State কি বললাম জানো? They pray for anticipatory learned lawyer for the state oppose the prayer. We have considered the materials on record, including statement of
the wife and daughter.
The wife and daughter of the deceased before magistrate. They claimed petitioner had asked victim deceased had asked the petitioners to refund monies which they refused and abetted suicide. Victim deceased has not left behind any suicide note. Whether conduct of the petitioner in failing to refund money would amount to abatement to suicide requires to be assessed at the appropriate stage of the proceeding. There is no chance of abscondence. Under such circumstances, we are inclined to grant it. Next.
In this case, the allegation against the patent petitioner that he, by unlawful means, he recorded his name as a Borgada. The record correction proceeding under section 57 of the.
All right, we have considered the materials on record. Dispute relates to alleged illegal entry in the land records. The matter is pending adjudication before the appropriate authority. Under such circumstances, custodial interrogation is not necessary and petitioner may be granted. Next.
But petitioners are the father, mother and the married sister of the principal accused. But Abhishek had a love relation with the victim. Thereafter, both the parties agreed to the marriage. Thereafter, the marriage broke. The victim committed suicide. Now, Abhishek is in custody. We are the parents and married sister of Abhishek.
Allegations are that for the marriage of the younger.
All right, petitioners are the parents of the
Parents and married
sister of the principal accused, who is in custody. Principal accused had promised to marry the victim, but later he demanded money and refused to marry. As a result, victim died. Keeping in mind the extent of complicity of the petitioners in the crime, we are inclined to grant anticipatory. Next.
And I am for the petitioner. Case has been started under section 406, 400.
My case there is coming.
Section
406, 409,
Not today.
420, 34.
Not today. 50.
50, my lord, I am for the petition. I am being led by Mr. Obik Ghotok, your lordship. This service could not be.
This is a case involving 354B. The opposite party could not be served.
We have considered the materials on record.
My lord, there's one issue, my lord. The
There was-
matter was not pressed a few days ago. We are before the same bench, so this is not a case of forum shopping. What was not there before your lordships on that day, not placed, my lord, I have also seen the video, is the fact that investigation has already ended. The injury is on the hand, the fracture is on the hand, my lord. Whether, my lord, section 307 at this stage, whether it should be determined, my lord. There are civil suits pending.
To surrender. All right, whatever, give the notice to the victim. Victim be notified. After vacation. Next. Just after vacation. After vacation, just after. Third. Next.
Not against these petitioners, 498/34.
So CD has not come, but charge sheet has already been submitted and against this.
Monday.
Well, 498/34.
Monday. Let them bring the CD. Next. Sonali Das.
My lord, deceased took loan from this petitioner. They were business partners. I asked for my loan for repayment. Now, my lord, he committed suicide.
This is the suicide note. Suicide note. He has stated that he has already made the payment and he has named specifically these two persons. They used to blackmail him. Petitioner number 1 is the partner and 2 is the employee.
It has been stated in the FIR, economically broken. That is why my father committed suicide. Me and my wife, my lord, they
He was made to sign some acknowledgements.
No, actually he has taken the money, but he has repaid it. That is written in the
not in full. My lord, 10 lakhs I insisted asking that 10 lakhs, me and my wife.
written in the FIR that
I am a old.
these persons also took money from the business. That is in the FIR. He has stated that I have already paid.
Petitioner submits there was monetary transactions
Initial
between
stage of investigation.
the petitioners and the deceased. He had not paid his dues. He committed suicide and petitioners have been falsely implicated. They pray for anticipatory bail. Learned lawyer for state opposed the prayer. We have considered the materials on record, including the suicide note. Suicide note discloses monetary transaction between the parties. It also alleges, deceased also alleged in the note. Deceased also alleged he was coerced to repay the amount, whether conduct of the petitioner to demand the outside, whether conduct of the petitioner would amount to abatement to suicide requires to be assessed at the appropriate stage of the proceeding. Keeping in mind the facts and circumstances of the case, we are of the opinion progress of investigation does not call for a custodial interrogation. Accordingly, we are inclined to grant answer. Next.
This is my application on 19/8/2021. I leased out my property guest house to a third party in lieu of 10 lakhs. On 14 onwards. And in 24, on 19/10/24, a raid was conducted there. And where there is a charge of 3, 4, 5, and 6 of the Immoral Traffic Act. And it's an allegation that I was there and I was fled out from there. But this is the allegation.
We have considered the materials on record. Petitioner contends he had leased out the property to another individual who carried on immoral traffic business. He prays for anticipatory bail. And a lawyer for the state opposes the prayer. Statement of witnesses show petitioner was involved in the prostitution business which was carried on in the house. Full stop. Document annexed lease notarial
14.
agreement
Yes.
annexed to the petitioner appears to be a camouflage for carrying on the illicit business in view of the nature of the crime, which has far-reaching social consequences and involvement of the petitioner therein. We are not inclined to grant that. Next.
My lord, as per IPC, my lord, 324, 307, 326.
Injury.
My lord, what
Injury report, my lord, we have said Monday.
Monday. Next.
I don't know. Well, I am for the petitioner. Well, after 13 years of marriage, well, this affair has been lodged. My petitioner 1 and 2 and mother-in-law, father-in-law, petitioner 3 and 4 and brother-in-law, sister-in-law. Husband is in custody, my lord.
Injury.
Injury report page number 40.
We have considered the materials on record. Allegations of torture are general and omnibus. Injury report discloses no external injury. Under such circumstances, we are inclined to grant anticipatory bail to the petitioners who are in-laws of the victim. Next.
I am for the petition, lordship.
Yes.
Section 135, 138.
Made 4,47,772.
Deposit 50%.
Lordship.
Petitioner undertakes to deposit 50% of the final assessment bill for unmetered consumption to the tune of so and so. Adjourned 3rd of January. 3rd of January.
Lordship.
Next.
But 498 at 307, husband, 3 years of marriage. She doesn't complain of anything within 3 years.
Injury report.
My lord, one day, my lord, does. There is a quarrel on 10th of November.
Injury
She
report.
leaves. Paper statement is also there. Her brother is also written up.
We have considered the materials on record. Statement of witnesses show petitioner physically assaulted his wife. Medical report supports the allegation. Accordingly, we are not inclined to grant anticipatory. Next.
But I am for the petitioner. But allegations are of forgery, cheating, and breach of trust. The family dispute. The daughter has lodged complaint against the 72-year-old mother, the sister's husband, domestic help. Case counter case, 2 civil suits pending by and between the parties.
Amount
Tomorrow, Monday? Monday.
Grateful.
Next.
The petitioner, lordship.
Offense.
Offense 307, 325 of the Indian Penal.
Monday.
That to David.
Well, I am for the petitioner. The petitioners are the brother-in-law, husband arrested and granted bail. The charge sheet submitted.
We have considered the materials on record. Petitioner is the brother-in-law.
Enter allegation against the husband.
He is not the principal accused. Keeping in mind the extent of complicity of the petitioner in the crime, we are inclined to grant anticipatory. Next.
But I am for the petitioner, my lord.
Yes, let us see the offense. 302.
No,
See, FIR name.
my lord, husband, father-in-law, mother-in-law, and Oja, Chanu Mumu, all are released on bail, my lord.
Maybe you will also be released on bail.
No, my lord, uncle-in-law, no allegation present
Let us
petition, my lord. Kindly see FIR. No allegation against me.
How did she die?
Husband released on bail, my lord.
Suicide, no. Petitioner is the uncle-in-law of the victim lady. In the FIR, there is no specific overt act alleged against her. Postmortem report shows death was due to effect of diseased condition of organs. That is due to natural causes. In view of the aforesaid circumstances, we are inclined to grant answer to that. Next.
We have not received the case diary.
Lord, I have received they are residing together, Lord, the love affairs.
Who are residing together?
Lord, the victim and Lord, the petitioner, because they have
Alright.
got married and they're residing.
Minor.
Lord, at the time of incident, but
All right.
slightly, Lord, 18.
Why victim has to be notified? Add victim as a party respondent. Officer in charge shall notify the victim with regard to pendency and a right to legal representation. Matter will appear 1 week after vacation.
No POXO, only child marriage.
It is submitted. Parties are residing together as husband and wife. It is submitted. There was a romantic relationship between the parties. Victim is presently major. Accordingly, petitioner shall not be arrested for 2 weeks on unlawful notice.
Not 65. I'm for the petitioner, my lord. After 8 years of marriage, my lord, victim has committed suicide, my lord.
Consider who is victim?
Victim is my lord, my ja, my lord. She is the, I am the
Sister-in-law.
wife of the brother-in-law, my lord.
We have considered the materials on record. Petitioner is the sister-in-law of the victim lady. She committed suicide 8 years after marriage. Statutory presumptions under 117, 118 BSA are not attracted. Under such circumstances, we are inclined to grant answer.
Grateful, my lord.
Next.
I'm for the petitioner.
Well, this is a renewal application. Well, kindly see what happened. Kindly see paragraph number, my lord. 8 and 9, my lord. My lord, he was in bed rest. My lord, kindly see all medical documents annexed, my lord.
We have considered the materials on record.
After submit charge sheet. After
Petitioner
Page 20, my lord, the order.
prayer for anticipatory bail materials on
Well,
record.
kindly see the 162,
Prayer
my
for
lord.
anticipatory bail was rejected earlier. Presently, it is contended petitioner was ill and could not have participated in
My
the
lord.
assault. This is an issue which may be agitated while considering the prayer for regular bail. Application for anticipatory bail is rejected. Next.
Grateful, lord. My lord, I am for
Next.
My lord, I am for the
What is it?
petitioner, my lord, allegations under section 107(2) and 110 of the BNS Act, my lord.
Consider the materials.
This is the 164, your lordship.
We have considered the
And there is
materials of
injury
record.
report.
Injuries are non-grievous. Under such circumstances, injuries are not grievous. Under such circumstances, we are inclined to grant anticipatory.
Grateful, my lord.
Next.
My lord, I am appearing for the petitioner. My lord, the main section is 307 and
68 and 88 could be taken together arising on.
68 and
83.
83.
34 explosive substance. Both we are, yes, my lord. My lord, ruling political party actually attacked me. Case has been started. Subsequently, this case has been started against the my lord entire my lord, 40 accused persons name.
68 and 83 will be taken up on Monday. And what is your counter case? What is your earlier case?
Earlier case, my lord, 570 of 20 to 24. Page 29, I have annexed.
Diary of Rotua PS 570 of 2024 be produced. Matter will appear on Monday.
Along with the 164 statement of the victim.
We are not stopping it. The investigation, whatever development they will produce on Monday. Get 164 statement, please produce us on Monday. Get
164 statement.
Next.
Lordship,
Action there. 570. Date it. 69.
Lordship, I am for the petitioner. Lordship, no specific allegation against the petitioner. Petitioner number 1, mother. Petitioner number 2, father. Petitioner number 3, brother. And petitioner number 4, uncle, Lordship. Lordship, 1 and 2.
What is against them?
Basically, their girl got married to the victim. Now, subsequently, the girl, along with the paramour, they committed murder.
They
of the
committed
husband.
murder.
Of the husband.
Okay.
Now, they are the in-laws of the victim,
Of that
victim's wife.
Okay, the girl's relations.
Lordship, yes.
We have considered the materials on record.
Paramour and that lady has been granted bail by the court.
Bail.
Lordship.
We have considered the materials on record. Daughter of which petitioner?
Lordship, petitioner number, accused number 1, Lordship.
Daughter of accused number 1.
Yes.
Petitioner number 1.
Lordship.
Daughter of petitioner number 1 and her paramour committed murder of her husband. Petitioners are the relations. Petitioner number 1, petitioner number petitioners are the relation of the said girl. Their complicity in the crime is based on suspicion. Principal accused have been released on regular bail. Under such circumstances, we are inclined to grant anticipatory bail. Next.
But I'm for the petitioner, Lordship. Lordship, the case is under section 108, 329, 351 of the BNS, Lordship. 108 relates to 306, Lordship, of the IPC. Lordship, this allegedly, Lordship, the complainant's wife had a relationship with me. Now, now what happened was I allegedly pressurized her to continue the relationship. She did not agree. Later on, she committed suicide.
Suicide notice there? Yes, ma'am.
Lordship,
Surrender. We have considered the materials on record. Petitioner had illicit relationship with the deceased. When she withdrew from the relationship, he harassed her and compelled her to commit suicide. In view of the aforesaid incriminating material, we are not inclined to grant anticipatory.
the wife of the complainant, Lordship. Wife of the complainant, Lordship. The complainant lodged the complaint.
Naturally.
Grateful, Lordship.
Next.
Lordship, I am for
And for the petitioner, Lordship, the
Yes.
prosecution case is under 25(1)(a) of the Arms Act.
What
Lordship,
was recovered?
a pipe gun was recovered.
All right,
From
we
the,
have
from the
considered.
roof of my house, not from
We
my.
have considered the materials on record. Firearm has already been recovered. Custodial interrogation for progress of investigation is not necessary. Accordingly, we are inclined to grant anticipatory bail subject to condition. Meet investigating officer once in a week.
I am grateful, Lordship.
Next.
Lordship, my prayer for this is a renewed prayer application.
We are rejecting.
Your Lordship, kindly, this application will be preferred after
Why
the.
you people don't arrest when we reject anticipatory bail or get a proclamation attachment if they are not available? Why these courts will be vexed by repeated applications for anticipatory bail? The prayer for anticipatory bail is a prayer for immediate relief. It seems as if it can continue for years.
Your Lordship, my prayer was rejected earlier last year, Your Lordship, in the month of
So
October.
last year, what steps have you taken?
Yeah.
What steps have you taken since the moment a prayer for anticipatory bail is rejected and you cannot arrest the person, you should initiate processes.
The circumstances in which I am filing this application is that my brother surrendered before the learned court. Thereafter, he was granted bail by this honorable court
Who will be
recently.
granted?
Your Lordship,
There
kindly
is no
see the main accused was granted bail long back, Your Lordship.
All
I am not the main accused here, Your Lordship.
Brilliant. Petitioner
And see the order dated.
prayer for anticipatory bail was rejected earlier on merits. It is contended petitioner is not the principal accused. However, role of the petitioner had been considered by the coordinate bench while turning down his prayer for anticipatory bail. We do not find any reason to revisit the issue. At this stage, application for anticipatory bail is rejected. Petitioner is directed to appear before the regular jurisdictional court within 7 days from date, and in the event and pray for regular bail. In the event he does so, the court shall consider his prayer independently and in accordance with law.
$35, my lord. Electricity Act, my lord.
Final assessment has.
135, my yes.
50% of the final assessment bill for unmetered consumption to the tune of so and so 3rd of January.
3rd of January.
Next.
Lord, I am for the petition. 76.
76. Yes, Genia.
My lord, the allegation under section 448, 323, 325, 307, 354, 34 of the Indian Penal Code, my lord.
Nature of injury.
Nature of injury is shown grievous.
Grievous. Statement.
Statement page 13. Another I will statement 9, 10.
पूरा बाँचेर लाठी दिए.
দুবার লিখেছি কেন এটা?
We have considered the materials on record. Petitioners assaulted the victim, resulting in fracture, injury, and hospitalization. In view of the aforesaid incriminating materials, we are not inclined to grant answer to it. Next. Next.
Item number 77, I'm for the petitioner, my lord, no nothing. You have to recover from me, my lord, based on the statement of co-accused, my lord.
We have considered the materials on record. Petitioner is involved in dealing in narcotics. Full stop. He did not join investigation and absconded. He has criminal antecedents. Investigation is going on.
Submitted, my lord, charge sheet. Page 30.
Further custodial interrogation during our further investigation may may result in further recoveries. In view of the nature of the crime, we are not inclined to grant answer to it.
Great.
My lord, I am appealing for the petitioner. Let's say, allegation under section 132 already another co-accused granted anticipatory bail.
Consider the materials on record.
By lordship.
Co-accused has been enlarged on bail, has been granted anticipatory bail. Petitioner stands on similar footing, same footing, and is entitled to similar relief.
Great.
Next.
79, I am for the petitioner. My lord, 7 years of love relationship. Thereafter, this complaint under section 318(2) and 69, my lord. My lord,
69, naturally.
318(2) and 69, my lord.
How long status quo in love will continue? It should crystallize.
th the Qazi sent the notice. 3rd she received, and 13th this has been initiated, my lord. My lord, with an allegation of 7 months, past 7 months.
Okay. Petitioner gave a notice to the Qazi for dissolution of marriage. In retaliation, the instant case has been registered. There is delay in lodging FIR. He prays for anticipatory bail.
The petitioner, my lord, he is a police officer, my lord, from Ketugram PS, my lord. That is the reason the more threat is coming, and
we will keep him outside. All right. A learned lawyer for the state and de facto complainant oppose the prayer. They contend petitioner number 1 is a police officer and is threatening the complainant. We have considered the materials on record. Notice to dissolve the marriage under Muslim rights and customs was issued. Subsequently, criminal case has been registered. There is delay in lodging first information report. Under such circumstances, we are inclined to grant anticipatory bail, however, subject to condition upon petitioner number 1 to instill confidence in the mind of de facto complainant. 10,002 sureties. Petitioner number 1 shall not enter Ketugram police station.
My lord, he is the SI of Ketugram police
So
station.
Murshidabad police station until further orders shall provide the address where he will reside and report to the officer in charge of the jurisdictional court where he shall presently reside. Next.
I'm grateful, my lord.
My lord, we are for the petitioner. Here, the case has been started at Ludhiana PS, and for that reason, transit anticipatory bail. Pray for the transit anticipatory bail. My lordship, your
All right.
lordship here.
State, who is state? Hey.
If no crores have been transferred to his account, that's why in a cyber case, he has been, 35 fee notice has been.
All right.
No, my lord. Okay, my lord. If your lordship come to the annexure, that is the 5, that is come to the page number 31. Na? Order.
31.
31, not 32. 31. My lord, 31. Where the
1.5 crores to that account from which
as per
money has come.
as per the order of the chief judicial magistrate, additional that amount, and not only that, my lord, the petitioner never.
The office state is directed to notify Aberdeen Police Station, Cybercrime Ludhiana with regard to pendency of proceeding. Matter will appear on 3rd of January.
My lord did not withdraw the use or use the money only. Grateful to your lordship.
In the meantime, petitioner shall cooperate with investigation.
Yes.
Grateful.
Grateful.
Next. Notice under section 35, subsection 3 BNSS has been issued. Petitioner apprehends arrest. In view of the issuance of notice under 35, subsection 3 BNSS, we are of the opinion there is no threat of immediate arrest. Petitioner shall respond to the said notice in accordance with law. Notice be issued upon so and so. Matter will appear on 3rd of January.
But my lord, on 9/8/2024, the police came and the Ludhiana police came with the Chachal PS, that is the local PS, and threatened that they.
Because you are not responding to the notice.
No, my lord, already the annexer G, that is email and all the statement. I already have been sent to the Ludhiana PS.
Oh, you have
Yes.
responded?
Yes, my lord.
Acha, tale kede dao. Petitioner responded to notice under section 35, subsection 3 BNSS. In spite thereof, he has been threatened with arrest. Notice be issued upon so and so. Matter will appear on with them. Give notice to Ludhiana.
Page কত বললেন? 31 to the nodal officer API.
ওটা নয়।
Let the notice be given to Ludhiana PS. You submit report. All right. Tell them that they can access online and participate in the proceeding. Huh?
Regarding that
response is I am unable to appear on this.
Yes.
Because the distance and significant and train tickets is not available. Now, that is the response, my lord.
Correct. So let us. He has responded to it. Now he's come before us. Let the Ludhiana police come over, make its response. We will pass appropriate order. We'll pass appropriate order. Let them place on record whether custodial interrogation is necessary. We would dismiss the application.
Grateful.
Next.
But 84. My lord, I'm for the petitioner, my lord. No, is it 84?
This 84 to 111 we have received after 5:30 yesterday. These files.
All right, let us see now. So what is the all right, you are allotted additional public prosecutor.
FIR lodge after 13 years of the incident, my lord, cheating, case of the cheating.
FIR?
After 13 years, my lord.
Petition, what is the allegation?
My lord, the allegation is that, my lord, these three petitioners took for a company 1 lakh rupees from the petitioner.
All right, petitioner submit that the dispute is civil in nature. There is inordinate delay in lodging first information report. You want Monday?
Monday, my lord.
All right, Monday.
Monday, all these will come.
Mondays. We are keeping this Monday.
My lord.
Next, if victim is to be notified, we will keep it after. Next.
Well, I am for the
My lord, I am for the petition, my lord. My lord, case under section 108 and 3 subsection 5 of BNS Act, my lord. My lord, petitioner is the brother. My lord, in item number 44, today's list, my lord, your lordship was pleased to grant anticipatory bail to the
All
mother.
right, as in 44. Yes, Amita, this matter relates to 44, item 44. So case diary is there in 44. Allowed.
Great.
44 is সংযোগ করে দাও। Next.
My lord, I am for the petitioner, my lord, co-accused statement, my lord, preparation of dacoity, my lord.
We have considered the materials on record. Petitioner has been falsely implicated in the instant case on the strength of statement of co-accused before police officer. Arms have already been recovered under such circumstances.
Only iron rod, my lord.
One iron made sword is not an arms.
My lord, I'm sorry.
All right. One iron pipe. Under such circumstances, we don't record anything without going through material. Under such circumstances, we are of the opinion custodial interrogation is not necessary, but petitioner requests to cooperate with investigation, meet investigating officer once in a week under further orders. Next. 88.
Not 88, my lord, I beg to appeal for the petitioner, my lord. First foremost, my lord, I beg unconditional apology. This is a change brief, my lord. The sections are mentioned, my lord, all along, my lord, in the petition, my lord, are wrong. The allegations is of 420, 406, 417. The FIR mentioned in the brief, my lord, is 341, 323, my lord.
Petitioner is at liberty to withdraw the application. Application is dismissed as not pressed, liberty to file afresh.
Great.
Next.
Let 4
Third. Third, we keep it on 6th.
And in the meantime,
Nothing. Yes, Mr. Arifin. You are sitting in anticipatory. What happened to school education?
holiday.
Huh?
Nowadays, Christmas vacation is on.
No, litigation, there is no Christmas vacation.
Code number 18 not sitting there.
Oh, code number 18 not sitting. All right.
Well, it is a very unfortunate case. His own property, his register, his sister-in-law, his own. When a son died, when a Muhammadan father, mother, all that.
Right. Petitioner content. Monday we are keeping it. Monday. Mr. Arifin, Monday. Next.
Item number 93, I'm for the petition, my lord, love and
108 of 108 of BNS, my lord. My lord,
Uh,
petitioner,
Abatement to suicide.
my lord.
So Monday,
Monday
let
would-
them bring the
fine,
case there.
fine.
Next.
Lord, I am for the petitioner. Lord, I have served, service completed. Lord, I just Lord get it from Lord the commissioner's office. Lord, this is the service. And Lord, one thing Lord, I am praying. Lord, that in my petition, Lord, I have stated that I have not moved any application for anticipatory bail before this Lord, the district judge. Lord, that is Lord incorrect statement. I made an supplementary
All
affidavit.
right, supplementary affidavit is placed on record. Officer in charge shall notify victim with regard to pendency of proceeding and a right to legal representation. Matter will appear on 6th. It is contended that petitioners have been. What is the offences?
Lord,
85.
Section 12 of the POCSO Act. Lord, these
'98, 304 mother-in-law, her daughter-in-law and son both committed suicide.
Then
First,
you
daughter.
tortured the son, you tortured the
No, chief. They had a quarrel.
Monday. They had a quarrel, both committed suicide. You are misbehaving with both of them, they commit suicide. Now who is going to take care of you? Let state take care of you. You go to jail. Next. Where is he? And
Husband already granted bail.
And daughter-in-law died.
No.
85.
Well,
All right.
husband already granted bail. The old
Monday, Mr. Maiti, Monday. Let them bring the case diary. Monday. Contact.
Lordship, all sections are 448.
Yeah, 307.
307,
So
Lordship.
let injury report
Yes,
come
yes.
Monday.
Lordship.
May please, Lordship. My lord, section 105 of the BNS, equivalent to 304 part 2. Petitioner, my lord, is the secretary of a particular rehabilitation center. Complainant's son was admitted due to his intoxication problem, my lord, in the month of March. My lord, he expired in the month of November, my lord.
Beat him up and killed him.
No, my lord, he died, my lord, due to chest disease, my lord. The postmortem, my lord, probably, my lord, would indicate that.
Mr. Ganguly, he has joined your club. No acknowledgement.
petitioner is the secretary, my lord, of the rehabilitation center.
Yeah, so you beat him up because
No, my lord, there is no allegation of
that's
beating.
the best way of dealing with a drug addict.
My lord, he was there.
Beat him up, die, take money for rehabilitation.
No, my lord, not at all. My lord, he, my lord, died due to his chest disease.
He died due to disease. One day.
Deeply.
My lord, it's a counter case, my lord, and we had filed up an anticipatory bail in 2 years before, my lord. That was rejected, my lord, but they did not file out any charge sheet also. And a counter case is a counter case. Our case was FIR 333 of 10th of August 2022, my
This is
lord.
22 case, sir.
Yes, my lord.
Then
2 years back, before we filed up the anticipatory, they did not file the charge sheet also. And
so
that
when
is,
you filed anticipatory bail, what happened?
that was rejected. by
Then
your-
you come up
But
after.
my lord, they did not. One more thing, my lord.
Please, sir. Please don't.
My lord, it's a counter case, my lord.
Whatever case, prayer for anticipatory bail was rejected in 2022. Thereafter, petitioners have absconded.
No, my
Presently, they pray for, renew their prayer. We find no reason to revisit the issue. We direct the petitioners to appear before the regular court and within 7 days from date and pray for bail before the jurisdictional court. In the event the petitioners do so, the court shall consider their bail prayer independently and in accordance with law. Sure. Next. Next.
My lord, the allegation,
Manna.
my lord, under the old section, the allegations are under section 447, 195A, 427, 506, 34 of the
427, 506.
34
So
of
what is the original case?
Well, there is dispute over a property. The complainant says that one morning when she waked up.
What is the original case?
Well, it's 325, 323.
What is the case number?
Well, I'm not having the case number.
Monday. Give the case number, we'll produce the case diary of both cases. Here the case diary, bring the case diary. If you can, ask the IO what is the principal case in respect of which the threat of witness was given. Both the cases will be brought. Next.
Inform করবে আমাকে।
In this matter, on behalf of Mr. Saurabh Mukherjee, I am pleading not today, my lord. Due to his medical emergency of his father, he left the court.
Monday.
Wait, please, Your Lordship, appearing for the petitioner. Well, cases under section 406, 420, 468. The petitioner number 2 and 3 are the uncles. Petitioner number 1 is the employee of a company. De facto complainant is the nephew of petitioner number 2. Allegation is that on 16th of May 2024, he came to the office and found the server missing. According to him, it has been stolen by the directors, other directors.
All right, Monday.
Very good.
Case diary.
আজকে কি হবে এত বললাম
Next.
Lord, I for the petitioner, Lord, 115, 117, 109 case, counter case, charge sheet file. I was also admitted. Monday, I'm not here, Lord, but Tuesday, I'm not here.
Oh, the junior will be.
Yes, Lord. Let it be Monday.
So we can dispose it off. If you want, we can keep it after vacation.
No, Lord, let it be on Monday, Lord.
All right, you wanted to petitioner submits there is case and counter case between parties.
Charge sheet.
He has been falsely implicated.
Others,
matter will appear on 6th of January. In view of the keeping in mind the facts of the case, state is directed to submit produce case diary along with injury report on the adjourned date. In view of the facts and circumstances of the case and the submission made by the petitioner, we direct petitioner shall not be arrested in this case for 2 weeks or until further notice. Next.
Main sections are, my lord, 118.2 and 109, my lord, 326 and main sections are, my lord, 118.
Injury we need Monday. Injury report. Next.
85 and 109.
I am the mother-in-law and brothers-in-law. Mother-in-law, and brothers-in-law.
Injury report Monday.
My lord, sections 108 and 3, subsection 5 of the BNS, my lord, arises out of a purely, my lord, financial transaction between a friend.
Monday, suicide note, whether suicide note is there.
Lord, after 8 years of marriage, my lord, victim has committed suicide, my lord, as item number 65, my lord. I'm brother-in-law.
Same
case, my lord.
All right, item 65, same order. Amita, 65.
No, sir, I have for the petition. 118 of subsection 2 of BNS and 110 of the BNS is 326 and 308.
Injury, not today. Otherwise, I was thinking that we could go up to 100 like this. So, bill
Yes, madam. I am for the petition, madam.
So we are adjourning it after
15th of January has to be.
All right. All right. Let this matter appear on
15th January.
17th of January.
16th and 15th.
That is why we are keeping it on 17th. So that what order is passed in that case we will consider. Right?
Another co-accused, Santi Ranjan.
Kothashina.
His prayer has been adjourned. His application has been adjourned on 15th. Mr.
All right, then 15th.
15th. And get.
Next.
Okay. 113.
Well, 116 to 19. These are Ponzi matters, my lord. I am in custody for 120 days. My lord, this charge sheet has been submitted long back.
Others are on bail.
Yes, my lord. This petitioner's mother was granted bail by your lordship, and sister. Yes, my lord. I don't claim that. But I
Then
First is 9 lakhs, then 30 lakhs, then another.
Don't file now, wait for some time.
May I not press?
Don't press this. Don't press these applications at least. Don't press, not press. Sure.
My lord, I am for the appellant. My lord, I can't start my video. My lord, it's saying the host has disabled it. Oh, now it's on. Yes. Yes. I am for the appellant, my lord.
Chaudhary,
My lord.
we do not have time. So
Lordship.
what we do is, and should, or rather should matter while I am in circuit.
Lordship.
When I am in circuit,
My lord, my lord.
but
My lord.
I will be in circuit from 20th of January.
My lord.
Let
Any
me
day after 20th.
so let me fix it on 24th of January
Lordship. 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 I'll be
or
grateful, my lord.
or maybe I can fix third, oh, third maybe a holiday. So we do it like this. Let me fix it on 21st,
Lordship. Lordship.
second day of the circuit,
Lordship. Lordship.
right?
My
At
lord. My lord.
2 p.m. or 3 p.m. And then
My
if
lord.
is required, we will finish it and
My lord. My lord.
take the records to send back to Jalpaiguri.
Yes, my lord.
Uh, matters will be taken up for hearing uh, on 21st of department records for hearing. So that we
Grateful, my lord. Yes.
for both of you.
Lordship. Lordship.
Thank you.
My lord.
Yes.
My lord, this is the contempt application, my lord.
Yes.
My lord, order have been passed, but hearing was concluded. But DM district magistrate order still now order not been passed.
Not been passed.
My lord. On 5/12/2024, hearing was concluded, my lord.
When was the hearing concluded?
5/12/2024, my lord.
5/12?
24, my lord.
Just take down. Petition in the present writ petition. In the present contempt petition is alleging that the respondent number 1 has failed to comply with the order dated 25/2024 passed by this court in WPA number 26209 of 2023. Full stop. It is the contention of the learned counsel for the petitioner that this court-wide order dated 20th/5/2024 directed the district magistrate, Paschim Midnapur, to decide petitioner's representation dated 28/10/2023 by way of a speaking order within a period of 8 weeks after affording an opportunity of hearing to the petitioner. Full stop. Learned counsel for the petitioner states that the district magistrate has concluded the hearing on 8 weeks is over, or there's still time left?
Already time was, my lord. My lord, order has been passed, my lord. This time
20th.
or lapse, my lord.
On 5/12/2024, but till date, no speaking order has been passed. Being aggrieved by the non-compliance of the order dated 20th/5/2024 in writ petition number 26209 of 2023, the petitioner has preferred the present contempt petition. Full stop. Learned counsel for the respondent number. There's nobody from the state.
My lord, this is the first time, my lord.
Learned counsel for the respondent number 1 shall file a response, shall file his affidavit in opposition within a period of 2 weeks. Reply to the same, if any, within 1 week thereafter. List after end of January, 4 weeks. List after 4 weeks.
Okay. Item 2 and 3.
Similar.
Original cost, my lord.
Same.
My lord.
2 and 3 same order. एक मिनट दिखाना, फाइल दिखाना. And in these matters also hearing has been concluded on the same day?
My lord.
Same order. Same order. For
I appear for the petitioner led by Mr. Saharai.
The private respondent is also there. The junior one said that the private respondent is after this court order for certain personal reasons, and he prays for that on his behalf. He has requested me to make a prayer that some other day will be taken.
All right.
Action has been taken
Not
by the-
unauthorized construction, my lord. The building plan that was sanctioned completely illegal since not in consonance with the building rule. This is the first issue.
At the request of the learned counsel for the respondent, right?
This for private respondent.
Private respondent,
8 and 9.
8 and 9. Let this matter be adjourned. Let this matter be adjourned.
Matter will appear on next available day.
Whenever available.
Under the same heading, same.
Same head.
But I am for the petition one. On the last occasion, your lordship was pleased to direct me to file an affidavit.
Yes, nobody is here.
This is my affidavit. And then on the last occasion, more submission has been made by the municipality that with regard to my
Nobody is there for the municipality.
petition. For my satisfaction, also kindly bear me 1 minute to look at one document of the affidavit. What is the stand of the municipality? What they are doing? Now they have said many things. But kindly come to straightway come to page 38 of my affidavit.
Yes.
Letters I will show that whatever my document with regard to. So minutes of the meeting of the municipality proceedings jail meeting, the border council municipality held on 19 September 2024. Now let's only skip the same. Now let's go to page 39. Resolution number 6. What is that, my lord? Regarding granting of permission of against the plan of high-rise building in Mindapur municipality area, Mr. Sofiullah, Honorable Councillor of Ward number 21, Mindapur stated that he has submitted a letter dates before the chairman regarding the against the issue of illegal permission of the high-rise building, but no fruitful reply has yet been received from him. He claimed this should be properly granted. Mr. Gopal Majhi, Honorable Councillor such and such, stated that as per sanction building plan, the owner of the building did not follow the building rules. Now let's kindly come to the next page.
Yes.
Regarding sanction of the high-rise building plan till date, Honorable Chairman has approached before the House that all the pending high-rise buildings shall have to be approved. Pending high-rise building. You will now kindly come to page 43. What is the list they have supplied? First one. PWD number and date. 1 by 1, 8/4/2021.
Yes.
Umpa Khan,
Yes.
the private respondent before your lordship.
Yes.
Post facto approval of the plan. There is no sanction plan. Had my client had the sufficient, I would have.
Who's for the municipality?
আমি কপি দিয়ে দিই তোমাকে দিয়ে দিয়েছি আজ করতে
But have you supplied a copy?
Yeah, I will supply.
Just give him a copy, let him file a response.
Yes.
Learned counsel for the respond. You appear for respond number? What is the respond number? Midnapur municipality is? Mr. Bhattacharya?
Yes, madam.
Respond number?
Brief টা বার কর। Just a second. The brief টা বার কর।
Respond number 1.
Respond number 1. Respond number 1.
You appear for 1, 2, 3, 4.
Yes. 1, 2, 3, 4, 5.
5. Learned counsel respond number 1 to 5. 6 time to file a response to the affidavit filed by the petitioner.
I have copy, handed over copy.
4 weeks time to file reply to the affidavit.
4 weeks, no?
How much time you want?
4 weeks.
Wow.
কোথায় যাবে হলিডেতে?
He's going out.
কোথাও তো যাবে না।
He's going out.
No, he is not going out.
3 weeks time.
As well.
much more submission has been made, and there is a document I can establish
List
post
after 4
facto
weeks.
approval. I'm grateful. man.
So item number 6, I am for the petitioner lordship led by Mr. Huda lordship. I am seeking pass over lordship. He is engaged in court number 16.
Pass over at 2 o'clock. after
Lordship,
lunch.
he is engaged in court number 16 lordship.
So no 5.
For the petitioner lordship.
Not today. Not today, sir.
Obliged.
My lord, I am for the petition. On behalf of my petitioner matter, I have the reply of the petition officer around the time, sir.
You want time?
Back, sir.
You want
After back, sir, matter.
you want to file reply to the affidavit in opposition? Learned counsel for the petitioner seeks time to file his reply to the affidavit in opposition. Let the same be done within a period of how much time? How much time?
2 weeks after vacation.
Within a period of 3 weeks. List after 4 weeks. Next.
Well, I am appearing for the petitioner.
Yes.
Documents to be translated, my lord. These are the translated for
My lord, all right. Can I see your lordship last order? Marriage certificate. There is order for marriage certificate, my lord. I have denied the marriage. But I have raised one.
Yes.
I have raised one point of law, my lord, where executive, departmental executive can declare there is a valid marriage or not, or only judicial, only the district court is empowered. That has to be decided first, my lord. Petitioner before my lord is a constable in the CISF. CISF Act and rule is applicable.
You have filed your affidavit in opposition.
Yes, my lord. Opposition is filed probably, man. It is with the record. What my learned friend is saying, my lord, that is correct. Actually, any decree of divorce, my lord, that can be passed either by the civil court, not either, my lord, by the civil court. But here difficulty is that, my lord, a lady, my lord, she made an application that I underwent a marriage with such and such person. We found it, my lord, that as on that date, my lord, in the court below, with the earlier wife, my lord, his marriage, my lord, that is under dispute, that litigation was going on.
Right.
So naturally, so long it subsists, my lord, in that time, my lord, you cannot undergo a second marriage. On that ground, my lord, we did it, the entire proceeding.
My lord, I have not entered into the second marriage. There is no marriage certificate. On the last occasion, lordship was pleased to direct.
The application sheet came to our hand, my lord, on that basis we...
Today, my lord, some documents have been given to me. I could not go through it.
You don't have the copy of this document?
My lord, marriage certificate? No, no. Documents just now have been given to me. I could not go through it.
Have a look. Not today.
Not
Have a
after,
look at
my
it.
lord. After vacation, my lord.
Not today. It will come after vacation only, sir. I'm not sitting.
হ্যাঁ এগুলো একটু তোমাদের কাছে রেখে দাও
I am for the petition. Mr. Rammohan is appearing for the other side. He has not come to court.
Lordship, I am for the state led by Mr. Pinaki Dhol. I am praying for not today.
Not today.
For the respondent, you know. Kindly take it up after vacation, my lord. In the meantime, I will kindly extend my time to file my opposition only, that much.
Fine. You have
But
not filed your...
we sent the draft to the department for waiting until my lord not yet confirmed. Because some official modernization work was
Learned counsel for the respondent. Your respond number?
all the respondent.
Learned Counsel for the respondent seeks further time of how much time?
4 weeks.
3 weeks to file her reply, to file her affidavit in opposition. Let the same be done within a period of 3 weeks. List after 4 weeks.
Lordship, in item number 11 and 13, Your Lordship, in both the matter, Mr. Kolelbashi is appearing for the petitioner, Your
Not
Lordship.
today.
Not today, Your Lordship.
And my lord, Merry Christmas and Happy New Year.
Thank you. Same to you, ma'am.
So item number 12 is also not today praying for.
Not today. 14.
14 Lordship, I am praying for not today.
Not today.
Grateful Lordship.
Lordship, item number 15, I am on behalf of the petitioner. Lordship, for the purpose of recollecting my memory, on earlier date, Lordship asked me the case number of the special leave petition, which is pending before the Honorable Apex Court.
Yes.
Lordship, the case number is SLP.
It's the same promotion thing which they're asking for.
Lordship,
Huh?
Lordship, and like it is a pending before the.
You give him the detail. Let him find out. Your department must be contesting it. You're aware of it.
My department has no information regarding this.
You must be a party in the Supreme Court also.
I don't know, my lord, where from.
Give him the details.
From internet,
Not today.
you will also be able to see it. And Lordship, on 2nd January, the matter may be heard.
Not today.
My lord, if your lordship kindly passes one line order, my lord, so that I can communicate to this my department.
Learned Counsel for the petitioner states that similar issue is pending. Just give me the details. Similar issue is pending before the Honorable Supreme Court in SLP Civil number 49043 of 2024.
This is diary number.
Why diary number? Similar matter is pending before the Supreme Court. Why diary number SLPC 49043 of 2024. Full stop. Learned Counsel for the petitioner further states that in view of the same, Learned Counsel for the petitioner states that the present petition shall be adjourned. Let this matter be adjourned, awaiting the outcome of the decision of the
I'm deeply obliged, Lordship.
court in
And
SLP
Lordship,
number
Happy Merry Christmas.
493 of 2024.
Happy Merry Christmas.
Thank you, same to you. Yeah, SLP number.
But academic supervisor matter, but Mr. Shishano Bandyopadhyay has promised me that he will do it in January.
All right, we'll do it in January.
But he is busy, my lord. He has said keep it
Not
in
today.
January. Not.
Happy New Year.
Happy New Year, my lord.
Item number 17.
17, nobody, not today.